Good afternoon, everyone. Thank you very much for joining me for this presentation. My presentation is on the potential impact of ILO Convention number 190, as well as ILO recommendation number 206. Both of them address the important and pertinent issue of eliminating sexual violence and harassment in the workplace. This, ladies and gentlemen, is an important basis for the ILO's work as it relates to decent work and the future of work. It was motivated primarily by the ILO's centenary objectives as the ILO enters its 100th year of existence. By way of background, it is crucial to note that the International Labour Organization has two very important conventions prior to the enactment of these two conventions that deal with discrimination. The first one is ILO Convention number 111, which deals with the prohibition and protection against discrimination of all workers in the workplace, and ILO Convention number 100, which prohibits the payment of different pay when different groups of people or different persons are performing work of equal value. These conventions form part of the 8 core ILO conventions linked to the need to show the ILO's attitude towards ensuring that there is no discrimination in the workplace and that there is no unequal pay for work of equal value. The ILO has also identified specific grounds that it deems important enough for this discrimination to not exist. These grounds range from gender, sex, pregnancy, status, and so on. However, there's a general consensus that was rising that these conventions don't go far enough in prohibiting violence and harassment in the world of work. They don't go enough in prohibiting violence and harassment in the world of work. Now, before we move on, it will be pertinent for us to uncover what exactly constitutes harassment and violence in the workplace. By way of harassment in the workplace can occur in 3 different ways. Harassment can occur in 3 different ways. Number 1, where a person harasses an employee in any form of unwanted verbal or non-verbal or physical contact that creates an intimidating, humiliating, or offensive environment or violates the employee's dignity. Number 2, harassment relates to unwelcome conduct which has the purpose of undermining an employee's dignity. And number 3, sexual harassment, which is the intimidating or humiliating, offensive conduct of a sexual nature. If a close look at ILO Conventions number 111 and ILO Conventions number 100 is that they don't expressly deal with these issues, and it's been a growing concern for some time that these this form of harassment in the world of work should not be tolerated and come to an end. Linked to harassment is the issue of violence in the workplace. Physical abuse or physical contact that should never be tolerated. Right? Now, why do these become very important? Why do these become very important? As you will remember and recall, an employer and an employee have various duties placed on them throughout the course of the employment relationship. The most fundamental being the duty to pay wages on the employer and the duty on the employee to come to work or provide these services in exchange for those wages. But these duties go beyond those two fundamental ones. There are other duties that are encompassed. But linked to the topic at hand is the duty of providing a safe working environment. Providing a safe working environment. An employer is obliged by the law, whether or not it's included in the contract of employment or not, to provide a safe working environment. A safe working environment entails various issues. Various issues include ensuring that the layout systems, the systems are in place to ensure that an employee is protected from safety when they're working. This also includes ensuring that they've got adequate training and supervision, and where necessary, protective clothing. This duty also ensures that all equipment, tools, and machinery where the employee works are reasonably safe for him to work. Right now, this is a common law duty placed on employers, an implied duty. Now, this hasn't always reflected in the manner in which employment relationships have been carried out. And thus was the birth of this ILO Convention number 190 and Recommendation 206 in recognition not only of the fact that violence and harassment should not be tolerated and should come to an end, but also for the fact that they are linked to this duty of providing and ensuring a safe working environment in the same way that an employer must provide all the equipment, tools, and machinery. They must also ensure that the working environment must be free from harassment and violence in all forms. So the recommendation lays down the principles. So the convention lays down the principles, whilst the recommendation itself provides detailed guidelines on how this is to be carried out. This is very, very important because there's a clear illustration from the ILO that this issue is something that must be dealt with quickly, must be dealt with swiftly, and something that cannot continue to go on. The result of ILO Convention number 190, read together with Convention 206, is that the right to work is that for the first time, the ILO has recognized the need for a world of work that is free from violence and harassment. And this has been articulated in international conventions. The recommendation, read together with the core convention, means that for the first time, there's a clear and common framework to prevent and address violence and harassment based on an inclusive, integrated, and gender-responsive approach. The instruments acknowledge that in the changing world of work, these issues must be dealt with at a fundamental level, considering the way and the route that the future of work is. There is no doubt, it's undeniable that violence and harassment in the world of work continue to remain prevalent, affecting many countries in a pervasive manner, and it goes to the extent of not only affecting someone's work arrangement, but someone's livelihood, given the importance of employment to people. As illustrated from the definition of harassment and violence, as illustrated from the definition of harassment and violence, these issues deprive people of their dignity. Each of the examples that I gave you indicate that harassment and violence go to the core of the dignity of a person, which makes it incompatible with the ILO's objectives of number one, social justice, and number two, decent work. The recognition by the ILO that not only must this issue be tackled with broad guidelines, but this is coupled with the recognition that because of demographic shifts, changes in work organizations and technology, these issues of sexual violence and harassment will continue to remain prevalent if not dealt with swiftly because of the future of work with all these particular issues, particularly in the manner in which the changes in the work organization are to be carried out. Because of these changes which the ILO anticipates, technological changes in work organization and demographic shifts, a failure to address this issue would have amounted to a dereliction of duty to some extent in not passing ILO Convention number 190 and 206. Based on this background, you can clearly see that these will have a phenomenal impact on employment relations throughout. The conventions are very important because they go in depth in proscribing a range of unacceptable behavior and practices, including threats that result in physical, psychological, sexual, or economic harm. They prescribe all of this conduct, and the definition even includes gender-based violence and harassment. It applies to all workers, and the broad definition means that a lot of conduct would fall into this definition, which becomes very important. As a result of this enactment of this ILO Convention number 190 and the recommendation, the principles are now clearly established that once ratified and hopefully domesticated by member countries, there will be a prohibition in law on violence and harassment. There will be an assurance that relevant policies are enacted to address violence and harassment, and there will be an establishment of a comprehensive strategy to implement measures to prevent and combat harassment, as well as the ILO Convention and recommendation prescribing that there must be enforcement and monitoring mechanisms to ensure that this level of contact, whenever it occurs, is not repeated. This, ladies and gentlemen, is a step in the right direction in ensuring that the conduct identified both under the common law as well as under this convention and recommendation is never spread but contained, because there's a directed effort towards ensuring that they do not undermine a person's relationship, employment relationship, based on these issues and based on this unacceptable conduct. The broad definition goes beyond physical and non-physical. In the non-physical, it even goes to the extent of saying things that might amount to economic harm, for example, economic harm and even psychological harm. And the strategies involved should be to recognize the sort of harassment and violence that is not so clear from the very beginning or from the get-go. Article 6, ladies and gentlemen, of the ILO Convention is very clear that each member state should adopt laws, regulations, and policies to ensure that the right to equality and non-discrimination is preserved. So this means that where, to the extent a country has adopted, so let's go firstly with not adopted 111 or 100 in this legislation. They are mandated to do so by virtue of this convention. But then furthermore, this convention says when you enact 111 and 100 into your legislation, you should also enact laws to address this issue of harassment. This shows you a comprehensive strategy that has been identified crucially to ensuring that all forms of discrimination, including this issue of harassment and violence, are addressed holistically, falling under this broad umbrella of saying in the future of work should be free from discrimination or arbitrary conduct that affects workers, particularly vulnerable workers and women workers. Article 6 of the convention should be read together with Article 7, which is clear that all laws, in addition to strategies on equality and non-discrimination, should also define and prohibit violence and harassment in the world of work. As always, there is adequate guidance from how this should be carried out, including consultations with workers and representatives on workplace policies, taking into account psychological risks and identifying hazards and risks to violence and harassment that need to be identified. The ILO, through this convention, is encouraging a system of tripartism where all relevant parties are brought to the table to discuss the manner in which a strategy and then subsequently laws and regulations can be enacted to ensure that these issues are adequately dealt with. The enforcement of these issues that have been mentioned in these ILO conventions is very clear and very nicely outlined. It says that there should be an effective dispute resolution and enforcement mechanism which will allow for the bringing of complaints, investigation procedures, dispute resolution mechanisms, and administrative support measures to deal with the complaints of victims. Above all, it also recognizes that they still need to protect the privacy of those people. There is still a need to protect the privacy of these people, and where possible, implement and adjust sanctions to ensure that these particular measures prevent others from doing it, from repeating the conduct because of the sanctions that are going to be levied against the people who condone or are perpetrating these acts. The view that I take from this landmark ILO Convention number 190 and recommendation 206 on violence and harassment is that the ILO has broadened the scope of this on discrimination in the workplace and ensuring equality by recognizing, based on the wide definition of harassment and violence, the conduct that undermines equality in the workplace and indirectly discriminates against women and vulnerable people because they haven't been dealt with. The enactment of this convention will crucially change the manner in which we view and understand discrimination in the workplace because it's been broadened to a sufficient extent to ensure that all forms of harm are prevented to some extent in the workplace. The only challenge now is adherence to the ILO Constitution, which prescribes that all conventions that are ratified should be brought before each country's national parliament and are brought before each country's national parliament for the objective of having it enacted into legislation. It is my hope that the recognition by the International Labour Conference in bringing up these international labour standards, there will be a recognition from member states of its importance given the gravity and level that has been put on eliminating discrimination.